All right, so it's 5:31. We're going to start policy committee. These are recorded, and so you kind of have an understanding of what we do. We just sort of pull up the policy that we're going to be reviewing. We read through the policy, and then we see what changes, if any, we think need to be made.
Okay.
Sarah's really good at looping in the statutes that correlate with whatever within the policy.
Okay.
So that we don't have to go searching for the statute.
Sure.
Which is great. We ended working on.
So before we start, that she is here representing nonprofits, and she had brought up that we should take a peek at our policies and look over nonprofits for our, which is why at the top the 42,
use.
yeah. Mm-hmm.
Okay.
So that's why that was brought. Was just the community use to see if we could look over and maybe come up with something to present the board for nonprofits for the community use.
Okay. Have you talked with Jessica Grantham, who's our CFO?
Mm-hmm. Yeah, she recommended that I speak with the clerk of the board.
Okay.
And then, so I spoke with her, and she said to come to this meeting to see if you guys could put something in front of the board.
Well, actually, what would be a better use is if you wanted to take the time to look through what it is and what you feel would be fair or reasonable, and just present that to the board. The board would be more than willing to listen to what you have to say.
So what I did was I drafted an email to the board.
Okay.
And then I did get a response from David Quimby,
Yeah.
I think. Said that he was going to look into it as well.
Right.
I followed up, I think a week or so later,
Okay.
and then Rebecca had wrote me, and I think maybe that's where she had recommended that I reach out to Jessica.
Okay.
So then I reached out to Jessica, and
So you think it's a runaround is what I hear. Okay.
Yeah. So I know the policy was just changed. The facility rates were just changed
Correct.
last June.
Correct.
When I spoke with Rebecca about it, she had just mentioned you guys tried to align them more with the rates
Obviously
that are
we're not in alignment if what you pointed out is accurate.
Yeah, with the rates in the area, which I mean they're pretty close, except there's the other schools like us going right now to Coeur d'Alene.
Right.
We go because of the nonprofit rate. So that's everything else is in a line. You're just missing that, which would benefit us significantly.
Okay.
Because everything we do, we have to go to the parents of our players who are,
Correct.
you know, they have kids in schools and everything costs tons of money.
I ran a club, I understand.
Yes, and it's like, you guys, it's going to be X amount of dollars, and now we have to
Right.
divide it by this many kids, and it's
Right.
that much more money from
Right.
you.
Right.
So we're trying really hard to make it affordable for kids to play.
Okay.
But with us being a spring and winter sport,
Okay.
but also in a competitive league where we need to practice year round,
Right.
we need to be able to use gyms.
Yeah.
To get
absolutely.
and we've used Garwood before. We use all indoor materials. We don't,
Right.
we're
Right.
respectful of it. So
Absolutely.
So that's why I was hoping to bring it back up and see if you guys.
Okay. Well, first, I apologize that you've gotten kind of the runaround of how to get to what you want to do. Regardless, at any point in time, anyone can present whatever they'd like to the board for consideration. I hear what you're saying. We don't have a caveat within our community use of school facilities for nonprofit. Did you bring something that shows?
I just
what you
brought,
want to-
I didn't know how many people would be here. I just brought Coeur d'Alene's
Okay.
just to show the categories. Sorry, I printed out a lot of copies.
That's fine.
So there's this one. And it's the category C is the nonprofit rate. There you go.
Thank you.
Okay.
Because when we're looking at, multiple hours, that's where it gets pretty significant.
Oh, I understand. I do understand. what I'm curious is if within their policy, for,
Oh, this is 1300.
I know that,
Oh,
thank you. I wanted to see if our policy had any language specific to nonprofit. So that's why I just flipped back to ours, but it doesn't. So here's Coeur d'Alene.
oh, that's, yeah, the
Oh, I get
other
what you're
one,
saying.
yeah,
Okay.
it's 42.
So our policy doesn't have any language in it about nonprofit. Alright, I'm just trying to see if they have a policy for, oh wait. Well, that's category, so theirs is 9605. School facilities, right there. So they don't have any language in here about nonprofit. Okay, so I suppose, why is that lined out on?
That's because it's been repealed.
Right, but then why is is it still on the policy, I guess?
Because when the policy was put in together, it was prior.
So you just lined it out?
Literally just now, yeah. I put the
Okay.
thing on there.
Alright, so doesn't, I thought it was, maybe I'm wrong. Okay, well, what I can do, we have a board meeting next week, and I can let the Board of Trustees know that you brought this, forward and are asking for us to create a category for, youth or nonprofit.
Okay.
And find out from them what direction they would like this to go.
Okay.
The policy and the modifications and all of the financial changes were brought to the board from our CFO. So I hear what you're saying, and I do think there's significant value because we've worked really hard with, like the city of Rathra and the city of Spirit Lake. So we do work with Park and Rec, but that's not the only source of community that utilizes our facilities. So obviously if we've overlooked something, which it looks like we have, there should be some resolve, but the direction should come from the board.
Okay.
Okay, I can't just, I mean, we typically wouldn't just bring the policy back. That's kind of a out of the loop process.
Okay.
But I don't appreciate how much running around that you've had with all the interactions with various people. It should have just, any time any community member has an issue with something, they're more than welcome to come to a board meeting and bring it out.
Okay.
We did all get your email.
Okay.
And so I will make sure that this goes before the board next, which is next, the
The third.
3rd, I believe, of December is our next meeting.
Okay.
And we will figure out how to resolve this.
Okay.
So that it's fair and reasonable for nonprofits and youth organizations.
Okay.
Okay?
Thank you so much.
No, not a problem. Thank you for
appreciate
coming.
it.
I
Yeah.
do appreciate that.
You're more than welcome to stay for the rest of it if you want.
I'm almost intrigued. Actually, I will stay.
It's totally up to you.
Because I'm curious, but you guys, if you don't.
You're more than welcome to, absolutely.
I'm gonna sit over here so I can see them, but.
Sure, yeah,
'cause
definitely.
I'm just interested.
Not a problem. Okay, so.
If that's the case, then we can go ahead and ignore then the 4210. The 42,
Yeah,
those
all
guys,
of these,
yeah. And then, so Rusty and Jake, I spoke to them about the next ones, the, if you pop down. Those ones. The student discipline one, they said that the number one things that they have are not in that one. They are in, I know exactly now what it is that they wanted. So the behavioral, scroll down just a little bit.
Support plan?
No, yes, behavioral support plan and notice of temporary suspension were the ones that had the changes.
Okay, there's no.
So that one should have those ones, but I believe maybe it's in that one. Yes, I had those things that were laid out.
Okay, so. Okay. Why would this, if this is his change, why is this before the committee?
It's not just that. If you scroll down. Oh,
Down.
on the other one.
I understand that, but I guess.
So I brought everything to the committee,
Okay.
just because that way we have it all included for the 3330s.
Okay.
So that has everything, just in case there was anything you wanted to go over there.
Okay, well, okay, so let's, I guess start with 3330.
And he had no suggestions for that.
Okay, so 2022. What? Okay, so.
There's just an update in it, and that's all.
Okay, but so the update is 18 USC 930, which is what we have listed, possession of firearms and dangerous weapons.
It's been updated since, if you click on it. So that shows you what we have. We have a more recent one.
I thought that was the
If you
recent
click on the
one.
no, go back to the website. Click on up there, view most recent version of the document.
Okay.
So it's been updated since, so.
But I guess what I'm not understanding is you've got it outdated. So are you talking about just this link?
No, there was no link. So what was used when this was originally put together
Uh-huh.
was back in 2022. It's been changed since then.
Okay. All right. Let me let's see here. Okay, so this was listed on here as this.
Mm-hmm. So what I'm trying to say is when it was created, we used all of those information. Since then, the law has changed on that one. So we need to look at the law and see if there's any of the changes that we should incorporate. Does that make sense?
Yeah, but possession of firearm and dangerous weapons in federal facilities is the same title of the law.
What I'm trying to say is the law itself may have changed. So we need to look at it to make sure that there's nothing that conflicts
Okay.
with how we originally had it. Does that make sense?
Well, okay, so you understand this was a policy that was fed down from ISBA,
Okay.
and the 18 USC 930 was their reference. That
Okay.
wasn't something that the school board or the policy committee put on there.
That's fine. It's changed since then, so I don't know if we want to look over that law and make sure that there's any changes that we need to incorporate into there. You see what I mean? So if the law back then stated you can only have 13 cherries, and the law says now you can only have 12, it's still, when it was written in reference to 13 cherries, not 12. Does
Okay,
that make sense?
did you go through it and see what
I
changed?
haven't had time to. Honestly, I have been so bogged down with everything with the student stuff, and there's just been no time.
Okay. Typically, they will identify what they've changed or what has been added or modified or reviewed. That is the information we need, because we're not going to read through the entire chapter 18.
It's fine. I just was highlighting the fact that it changed, and if we needed to see if it had anything to do with it, that's all.
Okay. So, disciplinary action may be taken against any student guilty of disobedience, or misconduct, including but not limited to habitual truancy, incorrigibility, academic dishonesty, conduct continuously disruptive of school discipline, or of the instructional effectiveness of the district, conduct or presence of a student when the same is detrimental to the health and safety of other pupils, using, possessing, distributing, purchasing, or selling tobacco products, using, possessing, distributing, purchasing, or selling vape products, using, possessing, distributing, purchasing, or selling alcoholic beverages. Students who are under the influence are not permitted to attend school functions and are treated as though they had alcohol in their possession. Using, possessing, distributing, purchasing, or selling illegal drugs or controlled substances and drug paraphernalia. Students who are under the influence are not permitted to attend school functions and are treated as though they had drugs in their possession. Using, possessing, controlling, or transferring a weapon in violation of the possession of weapons in school buildings section of this policy. Using, possessing, controlling, or transferring any object that reasonably could be considered or used as a weapon. Assembly of or public expression advocating for the use of substances that are illegal or to minors or otherwise prohibited within this policy. Disobeying directives from staff members or school officials and or rules and regulations governing student conduct. Using violence, force, noise, coercion, threats, intimidation, fear, or other comparable conduct toward anyone, or urging other students to engage in such conduct. Causing or attempting to cause damage to or stealing or attempting to steal school property or other person's property. Engaging in any activity that constitutes disorderly conduct and interference with school purposes or an educational function or which is disruptive to the educational environment. Unexcused absenteeism, however, the truancy statute and board policy will be utilized for chronic and habitual truants. Initiations. Hazing as defined in that. Did we bring? No, we did not. Okay. Harassment, bullying, cyberbullying, harassment, as defined in the policy, harassment, intimidation, cyberbullying, or bullying, as defined in that policy. Use of an electric communication device in violation of District Policy 3265. The foregoing of any signature or the making of any false entry or the authorization of any document used or intended to be used in connection with the operation of the school. These grounds for disciplinary action apply whenever the student's conduct is reasonably related to school or school activities, including but not limited to, on or within sight of school grounds before, during, or after school hours, or at any other time when the school is being used by a school group, off school grounds at a school-sponsored activity or event, or any activity or event which bears a reasonable relationship to school. Traveling to and from school or a school activity, function, or event, or anywhere, including off campus, if the conduct may reasonably be considered to be a threat or an attempted intimidation of a staff member or an interference with the education environment. Powers and duties of a teacher. Teacher shall have the power to adopt any reasonable rule or regulation to control and maintain discipline in and otherwise govern the classroom not inconsistent with any statute or rule or regulation of the Board of Trustees. Disciplinary measures. Disciplinary measures are designed to correct and address the student's misbehavior and include but are not limited to the following: expulsion, temporary suspension, detention, cleanup duty, loss of student privileges, loss of bus privileges, notification to juvenile authorities and or police, temporary removal from the classroom, meeting with the student and the student's parents, restitution for damages to school property, reflective activities, and community service activities within the school building. In the event a student is removed from the classroom for an extended period of time, or for the duration of the class period, or if administration is involved regarding the disciplinary measures, then the child's parents or guardians shall be contacted and made aware of the circumstances and situations. No person who is employed or engaged by the district may inflict or cause to be inflicted corporal punishment on a student. Corporal punishment does not include, and district personnel are permitted to use reasonable force as needed to maintain safety of other students. I don't like the way that's worded. Corporal punishment does not include, and district personnel are permitted to use reasonable force as needed to maintain safety for other students, school personnel, or other persons, or for the purpose of self-defense.
Do you have any suggestions on how it would
I was
be
gonna say,
worded
it's just
better?
confusing.
It's a very convoluted sentence. I think if we struck that out, so we're saying corporal punishment does not include reasonable force as needed to maintain safety for other students, school personnel, or other persons, or for the purpose of self-defense.
Yeah, I think that in district personnel are permitted to use is what's confusing everything.
Yeah, it's just plopped in the middle of that sentence.
Mm-hmm.
Okay. Just because I mean, we're saying corporal punishment isn't allowed, but corporal punishment doesn't include, which to me would mean that it leads to the fact that you can use.
Yes.
Alright. Temporary suspension. The superintendent or building principal may temporarily suspend any student for disciplinary reasons, including student harassment, intimidation, bullying, or cyberbullying, or for other conduct disruptive of good order or of the instructional effectiveness of the school. Prior to temporarily suspending any student, the superintendent or principal shall hold an informal hearing on the reasons for the suspension. During an informal hearing, parents and students have the opportunity to challenge the reasons for a temporary suspension. Due process procedures are as follows. No or low-level threat. Principals shall take a written statement from the student, any witnesses, and all other parties involved. After the written statements are collected, the principal, shall determine if a threat assessment investigation is needed. If a threat assessment investigation is not needed, then parents shall be contacted for an informal hearing. Okay. The informal hearing may take place in person or over the telephone and shall discuss the occurrence and situation and the consequences to be implemented. Mid-level threat. Principals shall take a written statement from the student, any witnesses, and all other parties involved. After the written statements are collected, the principal shall determine if a threat assessment investigation is needed. If a threat assessment investigation is not needed, the parents shall be contacted for an informal hearing. The informal hearing shall take place in person. Discussion shall be regarding the occurrence and situation, the consequence to be implemented, and the behavioral support plan shall be created and agreed to by all parties. Okay, so there's no behavioral support plan to a no or low level. Okay. High level. principal shall take a written statement from the student, any witnesses, and all other parties involved. After the written statements are collected, the principal shall determine if threat assessment investigation is needed. If a threat assessment investigation is determined what? Then parents shall be contacted, informing them of 1, a threat assessment investigation occurring involving their student and the student's temporary suspension. I don't think it should be determined, I think it is needed. Or we could say it's determined to be needed, because in these ones, we're saying they're not needed.
Is that threat assessment linked to the behavior plan?
No. Because a student a student's behavior may not rise to a threat.
Mm-hmm.
And so they would put the behavioral support plan in place to help the student navigate the educational environment.
Gotcha. I'm just wondering if any of the suggested removals that Jake put in would affect this policy for that portion.
Well, the procedure shouldn't affect the policy.
Oh, it was the notice of temporary suspension that was different. Never mind.
So that's just struck out.
Mm-hmm.
Okay.
Okay.
So if the threat assessment investigation is determined to be needed, then parents shall be contacted informing them of the threat assessment investigation occurring involving their student and the student's temporary suspension. The principal shall notify the superintendent of the occurrence and threat assessment investigation. The superintendent shall notify the board of trustees, or the board, of the threat assessment investigation, and a formal hearing date shall be determined. A temporary suspension shall not exceed 5 school days. The superintendent may extend the temporary suspension an additional 10 school days. The board may extend the temporary suspension for 5 more additional school days upon a finding that immediate return to school attendance by the temporarily suspended student would be detrimental to other students' health, welfare, or safety. Any student who has been temporarily suspended may be readmitted to the school pursuant to the terms of the behavioral support plan. The board of trustees shall, so we're doing that. So the board. The board of trustees shall be notified of any temporary suspensions, the reasons therefore, and in the response, if any. Students engaging in harassment, intimidation, bullying, and or cyberbullying shall be subject to policy 3295 and 3295P. The district reserves the right to appropriately address the conduct at issue and move directly to suspension or expulsion proceedings. A student who uses, possesses, controls, or transfers a firearm or any object that can reasonably be considered to be or look like a firearm while on school property or in those portions of any building, stadium, or other structure or school grounds at an activity sponsored by or through a school in this state while riding school provided transportation or while attending or participating in any school-sponsored activity, program, or event regardless of location, may be expelled for a period of not less than 1 year. The board may modify the expulsion period on a case-by-case basis as determined by the outcome of an expulsion hearing. Building administrator shall notify the appropriate law enforcement agency of any student who brings a firearm to school. If a student violating this policy is identified as disabled, either under IDEA or Section 504, a determination must be made whether the student's conduct is related to the disability. If the violation of the policy is due to a disability recognized by the IDEA or Section 504, lawful procedures for charges and placement must be followed. Any student subject to an expulsion shall be entitled to a formal hearing before the board. In accordance with Idaho Code and Board Policy. Exceptions. A firearm that is lawfully stored inside a locked vehicle on school property is an exception for any adult over 18 years of age and not enrolled in a public or private elementary or secondary school who has lawful possession of a firearm or other deadly or dangerous weapon secured and locked in his or her vehicle in an unobtrusive, non-threatening manner. Possession of firearms and dangerous weapons in federal facilities shall not apply to the lawful carrying of firearms or other dangerous weapons in a federal facility incident to hunting or other lawful possessions is an exception.
So how would that work for our students over the age of 18? They just,
What do you mean?
well, haven't we had instances before if the student's over the age of 18 and, oh, not enrolled, never mind.
Yeah. So D3. Where is A, B, C, D. Subsection A shall not apply to the lawful performance of official duties by an officer, agent, or employee of the United States. So I'm curious. That doesn't. Okay, so that's possession of firearms and dangerous weapons in federal facilities shall not apply to lawfully carrying of firearms and other dangerous weapons in a federal facility incident to hunting or other lawful purposes is an exception. Okay, so this part of that code still is in effect. Did you see that? Okay. Possession of a weapon on school property. It shall be unlawful for any person to possess a firearm or other deadly or dangerous weapon while on school property or in those portions of any building, stadium, or other structure on school grounds which, at the time of the violation, are being used for an activity sponsored by or through a school in the state or while riding school-provided transportation. This also applies to students of schools while attending or participating in any school-sponsored activity, program, or event regardless of location. As used in this section of the policy only, deadly or dangerous weapon means any weapon as defined in the United States Code. Such term does not include a pocket knife with a blade of less than 2.5 inches in length, and firearm means any firearm as defined in the United States Code. Any person who possesses, carries, or stores a weapon in a school building or on school property except as provided below, shall be referred to law enforcement and face disciplinary action by the district. The board Board of Trustees may grant persons and entities advanced permission to possess, carry, or store a weapon in a school building. All persons who wish to possess, carry, or store a weapon in a school building shall present this request to the board in a regular meeting. Granting permission is at the sole discretion of the board. In the event a deadly or dangerous weapon, firearm, and or other harmful objects are brought to school, or found on school property but not reported, the principal shall proceed with the investigative processes identified under the temporary suspension section to determine the level of threat assessment to proceed with. This section of this policy does not apply to law enforcement personnel, an adult over 18 years of age and not enrolled in a public or private elementary or secondary school who has lawful possession of a firearm or other deadly or dangerous weapon secured or locked in his or her vehicle in an unobtrusive and non-threatening manner. A person who lawfully possesses a firearm or other deadly or dangerous weapon in a private vehicle while delivering minor children, students, or school employees to and from school or a school activity. A person or persons protecting him or herself and or family by reasonable means necessary, defense of self or of another, or when coming to the aid of another whom he or she reasonably believes to be in imminent danger of or the victim of aggravated assault, robbery, rape, murder, or other heinous crime. Or a person or an employee of the school or district who is authorized to carry a firearm with the permission of the Board of Trustees. Non-discrimination. The district will ensure student discipline is enforced in a non-discriminatory manner. The policy shall be provided in writing at the beginning of each school year to the school personnel, parents, and students in the district. So, well, it's a darn good thing we have to review this annually. So let's, this will be the review. Significantly minor changes. This is fine. Okay. Written statement form.
Is that last policy, is that for law enforcement on and off duty? To be able to carry firearms? Cause it just says law enforcement personnel.
Well, I think what would be, where it would be, where law enforcement personnel that may not be on duty, would be like if you're a cop and your dad bringing your kids to school, you're definitely included
Yeah,
in that.
so if they're like going to an assembly or something and they carry, but they're not on duty, they wouldn't.
I don't know that they can bring it onto
Okay.
the school grounds. They can keep it in their vehicle.
Okay.
Yeah, I don't believe firearms are allowed on school grounds by anyone.
Yeah, I think it's just the uniformed officers.
Correct, yeah. Okay, so written statement form, school, name, date, describe the incident, dates, times it occurred. Were other individuals involved in the incidents? Did anyone witness it? Did you take any action? Any prior incidents? I think we need to ask if they've taken pictures, or if they have any evidences. Because I think it's important to know, who's photographing what. Mr. Taylor, superintendent of the Lakeland Joint School District, ordered this behavioral contract. Oh, no, 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 no. We do not have people sign contracts. Support plan is in effect for 1 calendar year from today's date. This, support plan is consistent with school administration and LJSD board policy. Consistent with school administration, what does that mean? That doesn't make any sense.
Should it just say is consistent with the LJSD board policy and add that policy number in there?
Well, it would be consistent with all of the
Or all,
policies.
okay.
Yeah. So, school administration what? I mean, it's consistent with what? That doesn't make sense. Maybe what they're trying to say, who knows? So the support plan is consistent with the LJSD board policy, and has been reviewed by school administration. I don't know if that's what they're trying to say, but I don't know. That just doesn't make any sense. Alright, in order to maintain my enrollment at whatever school, I understand I am required to meet the following conditions. I will continue my enrollment after I have completed any suspension days. I understand that I am required to be in full-time attendance during school Monday through Friday unless released by a parent or guardian. I will earn passing grades in all classes. I understand that the school campus will be closed for me for the duration of this. Upward, look at there. Can't spell either. For the duration of this support plan unless permission is granted by administration. I will be subject to random searches of my person or property while at school based on reasonable suspicion. The following will be determined upon an informal hearing as a condition to return to school. Educational component, classes, research, essay, school or community service hours. I will not be allowed to participate in any extracurricular activities, contests, events, or 40 school days pending reduction activities approved by school administration. Counseling referral. Is that a school counselor or is that okay, here's the thing. If this is for going to see the school counselor, we need to identify that. If we refer people to counseling, we have to pay for that. So we need to figure out what we're intending here. Yeah, because if the school district tells someone they have to go do something, then we have to pay for it.
Okay.
But if this is referring to the school counselor for guidance or advice or whatever, then we need to reword that. Let's just say school. Because maybe that is what they mean. other required activities. I understand that any violation of board policy 3330 that causes significant disruption to the learning environment will result in referral to the, just dock that, Board of Trustees for an expulsion hearing. Principal may terminate this behavioral support plan prior to the expiration date. Okey-doke. So, a little work on that one. Okay, this is F3. Alright. Notice of temporary suspension. You are hereby notified pursuant to the procedures adopted by the Board of Trustees. An informal hearing was held pertaining to the temporary suspension of the above named student enrolled in the Lakeland Joint School District. Reasons for temporary suspension, violation of policy 3330. Date of informal hearing, number of days suspended, dates of suspension. The student and parents, guardians were informed of the decision. Oh, date. Okay, so they want to take out, you are further notified that after completion of a threat assessment, the superintendent may impose, okay, you have a right to a formal hearing if you believe your child has been wrongfully suspended. A copy of this notice has been provided to the parent. Okay, so why are they taking this out?
Something to do with they don't use it. I can call Rusty real quick and see what the exact reason is.
Yes, yeah.
Hi, Rusty. I got you on speakerphone here for policy committee. We're going over that notice of temporary suspension where Jake had us remove the that section. Michelle just wanted to know why.
Yeah, we felt like it wasn't applicable in most situations. That's why.
But what about those situations that it is applicable to?
It's more than not. I mean, and again, Michelle, I would have to review it just right quick and just take a look at it just to make sure. I looked at it too, and in most cases that we've received the form, most cases the principals just put a line through it. If you wouldn't mind, could you, Sarah, can you read it out loud for me real quick just to make sure I fully understand?
You are further notified that after completion of a threat assessment, the superintendent may impose an additional 10-day suspension in the event that the board determines immediate return of temporary suspended student would be detrimental to other students' health, welfare, safety. The board
Right.
may, yeah.
I know why. It's the threat assessment.
The
We
threat
don't do threat assessments on every single individual situation, and that's kind of what the assumption is with the suspension. So,
Okay.
yeah, I mean, we don't need guidance on that. Obviously, if we have a threat assessment, then we have protocols that we follow.
Right, but the notice isn't to provide you all with guidance, it's to inform the parents that this is the process and that they could be looking at another 10 days if a threat assessment comes back and merits that.
Right, but again, in most cases, we don't have to do a threat assessment, and if we have to do a threat assessment, then we inform the parents that we'll be doing a threat assessment.
But it's not in writing.
Yeah, but again, it's just because each situation is so fluid, Michelle. I mean, that's
No,
that's
I
why.
absolutely understand that, but I believe the reason we've always had it is due to those situations where there is the threat assessment and we do have to impose the longer sentence because they are coming for a formal hearing. So I'm just cautioned by wanting to remove it.
Right.
Because
well, well, go ahead.
you don't want a parent coming back saying, I didn't know, it wasn't on the form, you never told me.
Right, but what it's doing is creating confusion with parents that it doesn't apply to. What do you mean we're going to do a threat assessment? It kind of gets them in panic mode. I mean, if we had an option that we will maybe check that we're going to apply a threat assessment or we're not going to apply a threat assessment, I guess that would be fine. But I think we need to go through notification because it's confusing parents in regards to, because threat assessment sounds pretty intimidating. And most recent, event, we didn't go through a threat assessment on those on that situation at all. But it was in there. So.
Okay. All right. So.
From an
Right.
outside perspective, I would just ask, what does it hurt to have it in there? It seems like it would be more detrimental to remove it. If it's not in writing, maybe you could just add something saying, if a threat assessment is needed, then yada 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 yada.
Yep.
True, but
I like that too. I really do.
But I think what you're also not acknowledging that you're removing is the fact that you have the authority to impose 10 more days of suspension, and the board can impose 5 more days of suspension, irrelevant to a threat assessment. It's not just the threat assessment that can cause 10 more days of suspension and then an additional 5 more days.
But the threat assessment has no applicability if we're going to add 10 days or not. That's our point. The way it reads is that we will do a threat assessment, and then there'll be 10 days additional, and and that's the issue. It's just confusing for administration and for parents.
Okay, then okay.
And this is coming from principals, and this is coming from Jake.
No,
who so.
I understand that. It just I do understand that, but this is just a significant change, and I think that it potentially needs correct wording as opposed to just being struck off saying it doesn't apply to most cases, because there will be that one case that it should have applied to, and then we are going to be in trouble. So.
Well, we don't need permission to do a threat assessment, Michelle. If we determine that the kid is a threat, then we're going to do it, regardless of the
I understand that, but if you're not notifying parents, then that's, because I think this is more of, we want to be more inclusive instead of exclusive, give them more information instead of less information, because parents have the right to know. So
I don't disagree with that at all. I don't, not at all. But I guarantee you, if we're going to do a threat assessment, we're going to involve the parent. We're going to have a conversation with them. In fact, if I remember correctly, the parent is involved in some of that questioning. So okay. I'm just I think I like kind of if a threat assessment is needed or warranted, that it will be yada yada yada. I don't know who else was in the room. I couldn't hear that. Was that Rebecca or? Yeah. So anyway, I kind of
it's
like
a parent.
that.
It's a parent.
Oh, sorry.
So okay. Well, I understand now why you've done what you've done, and I think basically there just needs to be clarifying language, maybe not necessarily just a blanket removal.
Okay, and
okay.
I'm fine with that. I'm good with that. Just clarify, go from there, and I understand your point where we're trying to notify parents, but again, when we're sending that form off and parents have a tendency to panic, what do you mean we're doing a threat assessment? And I'm like, no, we're not doing a threat assessment. Well, that's what it says you're doing. And it's like, no, we're just, the kid is suspended for 1 day. Well, it says you're doing a threat assessment, and that's really what we're running into. So.
Okay.
Okay.
All right.
Awesome. Thank you, Rusty.
Thank you for the call. I appreciate it. Thank you guys for working on it.
All right. Talk to you later. Bye.
Okay, so
Yeah, I agree with you, Michelle.
Yeah.
I think it would be, you want it in writing, because if somebody comes back, it's,
Yeah.
So,
and a lot of times people look for loopholes too.
absolutely, because this is their kid,
Yeah,
you know?
yep. Every
So-
parent, most parents will fight for their kids hard, so.
Absolutely.
I do see it though, if we have it, that after the completion of the threat assessment like that, you're notified that after, it does feel like, oh, okay, my kid
They're doing one.
talked back, he got, 1 day suspension for, being a kid, and now we're doing a threat assessment, what? So.
Let's go back to the policy. Poop. It didn't give me the boxes. Oh, I don't know where to get the box.
I can go back in and I think it's a bullet point,
Oh, maybe.
there's a checkbox bullet point.
I'll just figure this out in a moment. Oh, poop. There we go. Why are you not returning? Return to me. There we go. What is that little thread? Okay, cancel. So is it only, I know it's not only, okay. no, that's not right either. That statement's wrong. Because the board only imposes 5 additional days to ensure that a formal hearing for the student, the expulsion hearing, is met. We don't just impose 5 more days and say then they're no longer a detriment. Oh Lord. Okay, so if threat assessment is needed, then after completion of the threat assessment, the superintendent may impose an additional 10-day suspension. I'm wondering if this if a threat assessment is needed. So if we put this in there, okay, due process procedures, we're letting the parents know that whatever occurred is either a no or low level threat, mid-level threat, high level threat, and that a threat assessment is needed because not all mid-levels require a threat assessment. So if a threat assessment is needed, then after completion of the threat assessment, the superintendent may impose an additional 10-day suspension. If necessary, the board may impose an additional 5-day suspension prior to a formal hearing for any student subject to expulsion. You have a right to a formal hearing before the board if you believe your child has been wrongfully suspended. Is that clear?
Mm-hmm.
Do we need to identify what consists as low level, mid-level, high level? Is that defined somewhere?
It's defined in the policy
Is that
right here.
up higher? Oh yeah.
That's where I just, because I wanted to see what we were
What we were
doing.
okay.
So that's why I just thought, well, we're calling it due process procedures, so that's what we're gonna say here. So this is what they've done. So their due process, is it a mid, a low, or a high level? And then do they need a threat assessment? So we're clearly identifying whether or not we need to do it. And then we're letting them know if threat assessment's needed, then after the completion, the superintendent can impose another 10 days. And if necessary, the board may need to impose another 5 days prior to a formal hearing for any student subject to expulsion.
This is for the parents?
Correct.
So above where it says the no or low level,
Uh-huh.
where it says the due process procedures, should you put as defined in policy 3330, or they're gonna be like, what does it mean that they're mid-level?
Right. So does that seem fair to
Mhm.
say identified in policy 3330?
Yeah, that's very clear.
Okay. So they can reflect back or they can ask for a copy or whatnot.
Yeah.
So you have the right to a formal hearing before the board if you believe your child has been wrongfully suspended. So that's even before any,
Mm-hmm.
But what I'm wondering is if this statement
Should be above that one.
Yeah.
Yeah, I was thinking that.
So I'm just gonna make this whole thing red. Oops, wrong red. So they have the right to know that right out the gate, if they want a formal hearing, they can
Mhm.
request it. And then we're gonna say this is the due process procedure, and that if a threat assessment's needed, then here's where we're at, and
This is how you've been notified.
that's right. So that, this feels way more informative than what we had before, which I think is pretty cool. Oopsies. There we go. Okay. All right. Okay, so we did all 3 of those. Okay, so you can, I guess, give those back to Rusty and then we'll figure out where to go from there. We only have 10 minutes left. Darn. I don't want to get into uniform grievance because there's too much.
Too much to unpack.
Yeah, in 10 minutes. So, we can, yeah. If you can put policy 1300 for it to come next week, that would be great.
Yes. So I was able to locate in the minutes and everything what we did with that. So it's actually ready to go to the board for the first read.
Okay.
We can bring it back to policy committee though, absolutely.
Yeah, I don't remember, I think it would be better for it to come to the
Yeah.
committee to see, because it went out for parent survey and all that. Or did we not?
I believe so. I have to go back through my records and see if
Okay,
I have that.
so we're gonna end 10 minutes early tonight. Where's the thingy? There it is. So it is 6:50, and we'll go ahead and